Senator Tantateta, Quatin Leslie McGuan is back in session. I believe when we broke yesterday afternoon, Senator St. Nicholas, you had the floor.
Thank you, Mr. Speaker, and thank you for your leadership towards the close of session yesterday. In consultation with the author of the measure, we have made some determinations as to how to proceed, and I will go ahead and withdraw my concerns and yield to the author.
Thank you. Senator Ada, you're recognized.
Thank you, Mr. Speaker. Mr. Speaker, notwithstanding the House rules, I'd like to move that on Bill 53-34 LS that a new version, and it reads 53-34 LS, as amended by the Committee on Environment, Agriculture, Land and Procurement Reform, and as substituted on the floor, be accepted. And I would like to discuss that version.
Does everybody have a copy of the as substituted? Everyone? First, but before I ask to accept, I just need to know everybody has it. On the motion to accept, any objection? There being no objection, so ordered. The substituted version is accepted.
Thank you, Mr. Speaker. So, Mr. Speaker, the substitute version that we are now discussing is actually simplified, and all it does is it rescinds the administrative jurisdiction of Lot 7116-1-2. And that, by rescinding that administrative jurisdiction, it will automatically then, by default, cause this particular lot to revert to the Chamorro Land Trust inventory. Legal counsel informed me yesterday, and my staff is also looking at that specific provision in Public Law 2218 and the specific provision in the Chamorro Land Trust law, which states that when the government no longer needs the property for which it reserved it for, that property automatically reverts into the Chamorro Land Trust inventory. So I'm going on the basis that by rescinding that administrative jurisdiction on that particular lot, it will then trigger off other events which will achieve the objective that we are looking for, and that is to ultimately get that lot into the Chamorro Land Trust inventory. And so, Mr. Speaker, I would ask my colleagues to favorably consider this particular bill. Thank you very much.
Thank you very much, Senator Ada. Senator Nelson, you recognized on the main motion, 53-34 as substituted.
Thank you, Mr. Speaker. I just want to express my support for this amended version of Bill 53-34. I also would like to state for the record that in future land dealings, we pay close attention to subsection 2107, Title 2 GCA. And if there should be any conflicts with further land bills being proposed, I recommend that we remedy this law first before we proceed with those actions.
Thank you, Senator Nelson. Any other senator wish to be heard on the main motion, 53-34, as substituted? Any other senator wish to be heard? If not, the author is invited to close. On the motion to send Bill 53-34 to the voting file, any objection? There being no objection. 67-34. Senator Addy, you're recognized.
Thank you, Mr. Speaker. Mr. Speaker, notwithstanding the House rules, I'd like to move that on Bill 67-34 that we accept a new version which reads on the top there, Bill 67-34 COR, as amended by the Committee on Environment, Agriculture, Land, and Procurement Reform, and substituted on the floor.
Any objection? You're
Thank you.
recognized to speak.
So, Mr. Speaker, the substitute version of the bill is similar to the bill that we had just sent down to the voting file. And all it does, again, is it rescinds the administrative jurisdiction of Lot 7116-1-2-3. And again, by rescinding that administrative jurisdiction, it will automatically trigger other actions to follow as provided for in Guam law. Specifically, that when the government no longer needs that property that it previously reserved for that purpose, that property then automatically reverts to the Chamorro Land Trust inventory, and we would have achieved then what we set out to do from the very beginning. So again, I ask my colleagues to support this, and as I tried to emphasize yesterday, you know, we're talking about 3.5 acres of land. It seems like 3.5 acres, so what? Well, it's a big deal for at least one of the Chamorro Land Trust tenants on that property, because until he is able to get the appropriate lot size that he needs, he won't be able to build that house for his family, for which he already has a Veterans Administration loan that's just standing in the wings, waiting to be issued, provided that certain issues need to be resolved at the Chamorro Land Trust. So it is a big deal for that individual. You know, it means the world to him and his family, and subsequently to the other families that may soon be settling in on those properties. So I ask my colleagues to favorably consider this bill. Thank you.
Thank you very much, Senator Addick. Any senator wish to be heard on the main motion? Senator Nelson.
Speaker, I'd just like to state I am in support of this bill. However, I invite all of us to really come together and find a true remedy, not for just one individual, but to ensure that the Chamorro Land Trust lands that were promised to the numerous applicants be sent out immediately, as well with the same tenacity we are addressing this one individual. Thank you, Mr. Speaker.
Thank you very much. Any other senator wish to be heard on 67-34 as substituted? None? There being none, again, the sponsor is invited to close. On the motion to send 67-34 to the voting file, any objection? There being none. Is there any need to deal with 52, or is 52 okay? Okay. Okay. Yeah, but I'm just wondering whether or not we had to bring it back up.
We're fine with that.
All right. 6. Madam 71-34, Madam Vice Speaker, you're recognized.
Good morning, Mr. Speaker and colleagues, and I would like to make a motion to place Bill number 71-34 on the third reading file and make some discussion on this bill. The Organic Act authorizes the governor to issue executive orders that are not in conflict with any applicable law. This bill will help ensure that the public is informed when executive orders are issued affecting the operations of the government of Guam. It sets the effective date of an executive order to be midnight of the day it is transmitted to the Guam Legislature and to the compiler of laws. The compiler of laws is currently responsible for publishing legal evidence of the executive orders and all the laws of Guam. And this is the same effective date that is currently set in statute, as you can see in Section 102, for all laws and all resolutions. So this would make executive orders not effective until they are actually transmitted. Currently, there's no existing guarantee that the people of Guam will be notified of the executive order or the operational changes that are mandated therein. In fact, none of the executive orders issued in 2017 were transmitted to the legislature or to the compiler, and none were published on the governor's website. In the past, executive orders have been used to declare emergencies, to implement operating procedures, establish many agencies sometimes, to transfer agencies. For example, they transferred, well, not an agency, but the Chamorro village from under DCA to GIDA by executive order recently. And these are all things, Mr. Speaker, that I believe the public has a right to know about when they occur. Both the compiler and the governor's office have provided testimony in support of this bill. And I humbly ask my colleagues to please support the passage of this bill so that the public can be informed of these very important operational operational changes that affect their lives. Thank you, Mr. Speaker.
Thank you very much, Madam Speaker, Vice Speaker. On the main motion, 71-34, any senator wish to be heard? Senator Lee. After Senator Lee, any other senator?
Thank you, Mr. Speaker. Point of inquiry. The bill states that executive orders are effective at midnight on the day the executive order was issued. So midnight can be defined as either the beginning of the day or the end of the day. So for the purpose of this act, would the author yield to a question, could further clarify the intended meaning of midnight? Is it necessary to define midnight? Is it amenable to just say that the effective dates of the executive orders will be effective at 11:59 p.m. on the day the executive order was issued?
I'm not sure the moment of midnight is defined. However, the word midnight is used for the effective date of bills and the effective date of resolutions. So I just mirrored that language, but I have no objection to putting 11:59 or something more exact. But currently the word midnight mirrors the use of the word for the effective date of bills and resolutions, so I would take it that there's a definition for it somewhere.
Senator Lee. So is it going to remain midnight, or are you going to take the 11:59 of the day, or the day it is issued? Madam Vice Speaker, is it going to be midnight or 11:59 p.m. of the day the issue is ordered? The executive order is issued. Okay. All right, we'll just leave it at midnight. It's understood. Okay. Any other senator wish to be heard? Senator Argan.
Buenas, Mr. Speaker, and fellow colleagues. Mr. Speaker, I just have a couple of questions. And first of all, I want to clarify, just for the information of members in the community, that there's an exception clause here, and which is very, very critical. And it reads, with exception to those declaring a state of emergency. And we recognize that any time that there's an emergency out there that directly affects health and safety, that certainly we don't want to restrict by virtue of a time machine or a clock that restrict the chief executive from effectuating some immediate needs when it comes to an emergency. The one question I have, though, Mr. Speaker, and this is lingering in my mind, is are we able to restrict or to set time restrictions or effective timelines on executive orders? Because my understanding is that executive orders are subject to to some extent, the separation of branches. It governs the executive branch, and any executive order that impacts the executive branch, the chief executive certainly is the sole individual responsible for administering the executive functions of this government. So that's really one of the questions that I ask, whether we as a legislative body can affect or influence the timelines or the implementation of an executive order which is within the prerogative of the chief executive. It's just like signing off on a letter of memorandum notifying all of your cabinet members, as an example, that certain things will take effect. So I'm trying to reconcile that particular thought, whether we as a legislative branch can directly influence or affect the implementation or timeline of an executive order. Mr. Speaker, if the sponsor of the legislation can please
Do you
yield.
yield?
Yes, I do, Mr. Speaker.
Thank you.
I think there would always be a lingering constitutional argument that we will not resolve today, but it has been done in other jurisdictions, including in the United States, for the president's executive orders, that there are mandates that those go to the Attorney General, to different places, and that they actually are published before they are effective. So I believe this is something that reasonable that we can attempt to do, and I think the governor's office has agreed that it doesn't impair his powers at this point, and particularly with the emergency clause that you pointed out.
Okay. Thank you very much, Madam Vice Speaker. Thank you very much, Mr. Speaker. I just wanted to ensure that there was clarity there, and then at least it reconciles my concern. Thank you very much.
Any other senator wish to be heard? Senator Espaldon?
Thank you, Mr. Speaker. Mr. Speaker, I understand why the author of this bill put it in, because sometimes we do not get notice of executive orders and sometimes have no bearing or knowledge of things that we should be knowledgeable about. However, I do have to question also, much like the previous speaker, just the separation of powers issue. In the United States, let's take it at the presidential level, bottom line, the president has the authority, in essence, to create laws or regulations that basically affect the agencies that he has jurisdiction over. In this particular case, as was mentioned by the author, the transfer of the Chamorro Land Trust, whose jurisdiction falls under the governor, was transferred from one agency to another. I'm just not sure that we aren't impinging upon the power of our chief executive to say that your executive order, in the United States, excuse me, let me go back to that, United States, once the president signs his executive order, it's effective. It's not based upon any transmittal or any receiving of that executive order by another branch of government. It becomes effective upon his signature. This now we're saying that even after he signs it, that it doesn't become effective till midnight, until after he transmits it, and I would imagine to go with that until after we receive it. And it doesn't say that here, but it says after transmittal. But does that mean also that if we do not receive it officially, that it's not considered effective? Because if that's the case, then one branch of government could conceivably nullify the executive order by not officially receiving it. It may have been transmitted but not received. And so this might impinge upon the authority of our chief executive to issue an executive order in which he believes in the best interest of our government, right? And yet he has a full purview to be able to do, but may not become effective only because we're mandating that it doesn't become effective until he transmits it, and I would imagine until we receive it. So I have a problem with that concept. It is within his power. I believe, to be able to issue an executive order, and it becomes effective the moment his signature is placed on it, not upon transmittal, but upon his signature. That's the way the other jurisdictions, and even the United States President, how that is played out. So, and I understand. It would be nice to be able to, yes, it is important that we receive that information as quickly as possible, but to mandate that it doesn't become effective until it's transmitted, and like I said, by implication, that it's received, that this is something that we should be doing, impinging upon the power of the governor to be able to use his authority to issue an executive order. And perhaps if the author could perhaps speak to that separation of powers, I would appreciate it.
Madam Vice Speaker, do you yield, or do you wish to comment?
Sure, Mr. Speaker, and thank you for the questions. The Organic Act says he shall have the power to issue executive orders and regulations not in conflict with any applicable law. And I believe it is within the power of the legislature to issue laws that really do not stop him from issuing executive orders. They only affect the effective date of those. And they don't require any receipt by anyone. They require transmittal. All of this still within the power of the governor. And that word actually was mirroring other jurisdictions, because, yeah, we didn't want to say receipt where there would be some kind of power that we had to do over in another branch. So we kept it all it's all still within his power. And I think, when we're talking about separation of powers, this really just sets an effective date of executive orders that are they impact the entire government of Guam. And currently, we can't even do that with laws without anyone knowing about them. And this is really for the people of Guam. It's to protect them, make sure that they are aware, and that they are the ones who will be affected, and so that they are aware when these things occur. And it doesn't restrict the governor at all from doing what he needs to do. The executive orders will still be effective. He can still pass this. This doesn't stop him from doing that at all. In fact, it allows him, when there's an emergency, of course, to make it effective immediately. And when there's not an emergency, it makes it effective at midnight. And the governor's office has agreed that that is absolutely reasonable, and they were willing to comply with this. I was also given a citation from the legal counsel, by the way, that says that midnight of any given day is 12 o'clock post-meridian p.m., the end of the day. That's from Section 1008 of Title I. But so I just think, and when I maybe misspoke earlier. It's when I said the president has to do other things before his executive orders. You're right. When he signs it, that's the end. But before he signs it, things have to happen with that. And Congress has been the one that mandates that procedure. So I hope that answers the questions from the body, Mr. Speaker. Or if there's any more, I'm willing.
Is that satisfactory, Senator?
Well, I appreciate the answer, and I'll mull that over in my head. However, it's interesting to note that, she did say that the note from the legal counsel is that midnight is 12 p.m. 12 p.m. normally is identified as noontime. And so maybe we need to take a look at that law, because 12 a.m. is technically midnight. And that's just a point. But again, it then calls into question, if we are trying to live by the letter of the law, that it becomes effective at 12 p.m. and they said midnight, then there's a conflict. So again, there is a conflict between this law of midnight, identified as 12 p.m., right, which is technically noon. But thank you, Mr. Speaker. Again, I still have a question of whether we can. I will definitely consider it. I understand the necessity for having knowledge of executive orders, And so I'm not opposed to it. I just have to at least question, again, the separation of powers issue. Thank you, Mr. Speaker.
Thank you very much. Any other senator wish to be heard? Senator Nicholas.
Thank you, Mr. Speaker. I've been listening intently to some of the concerns with respect to separation of powers. I think we may have a very simple fix that might smooth all of that over. On page 2, line 16, after the word governor, if we simply insert a comma, and after the word and insert the words shall be further, then basically what we will be saying is that executive orders shall be effective at midnight, comma, and shall be further transmitted to the Speaker and the compiler of laws. So if we just add those two simple semantics into the section there, it might cover all those things. So I'll go ahead and proffer the amendment. A comma after the word governor on line 16, and also on line 16 after the word and, adding the words shall be further.
Did everybody get this Nicholas amendment? On line 16, put a comma so that the effective date of the executive order shall be at midnight the day the executive orders are issued by the governor, comma, and insert shall be further transmitted to the Speaker.
It seems like a reasonable amendment. However, I guess in terms of the concern of the author on this one was when is it transmitted, and just the verbiage alone, and shall be further transmitted, it doesn't really give a timeline of when the executive orders shall be transmitted. And I believe the intent of this legislation was to make sure that as soon as the executive order is signed, that we receive notice of that executive order. But again, it does not. I mean, if he signs an executive order and it becomes effective, but doesn't transfer it until 2 weeks later, again, that verbiage allows for it. And again, I appreciate this particular amendment, but again, there is that little bit of discrepancy, I believe, in terms of not addressing what the intent of the author of this bill is. But I have no objection to this amendment. Thank you.
Thank you. On this Nicholas amendment, do you wish to speak, Madam Vice Speaker? Please, recognized.
Mr. Speaker, with all due respect, I would object to this amendment because, as the previous speaker said, it's true that this amendment would nullify the purpose of this bill. The purpose of this bill is so that we are notified when these executive orders become effective, so that the public is notified immediately. Not to stop the executive orders, but to notify the public of when they become effective. And as the example was just exactly, that example is correct, that the change would allow us and the public not to be notified until who knows when after it becomes effective. And really that's the whole point. Right now, they're probably supposed to be transmitting all executive orders to the compiler. The compiler said she hasn't received any for a very long time. And when we need to see executive orders, we track them down. I mean, I don't know if you've ever tried to do this. It's very difficult. So I understand the intent, but I think it's going to nullify the intent of the bill, which is that the public's notified immediately when these executive orders are issued. Thank you, Mr. Speaker.
Senator Nicholas, the sponsor has objected to your amendment.
That's fine. We can vote on the amendment. We can vote on the objection. I mean, there's a suggestion to add within 24 hours, Mr. Speaker, but we can go ahead and vote on this amendment, and then if it doesn't pass, then it's moot. I think that it helps to enhance the bill, and so, I mean, if we want to vote down an improvement, that's entirely up to the will of the body.
Okay. There's been an amendment offered by Senator Nicholas. It's been objected to by the sponsor. All those in favor?
Mr. Speaker, if I may, notwithstanding the House rules, if I may propose that amendment to the amendment then, as was mentioned by the mover of this amendment, and that would be after governor, comma, and shall be further transmitted within 24 hours. That way there is notice, but it won't, that way, but the executive order is not effective based upon the transmittal to the legislature, but basically what we're saying is that the executive order would become effective upon the signing, but he needs to at least inform us and the public within 24 hours of the signing of that executive order.
Madam Vice Speaker, does that address your concerns? There wasn't, if I was to allow the Espaldon amendment to the Sir Nicholas amendment, notwithstanding the House rules, would that satisfy you and satisfy your notice need? I'm going to take a short recess.
Thank you.
Thank you.
legislature is back in session.
Mr. Speaker, if I may, I made an amendment to the amendment by Senator Nicholas, and so at this point, after discussion with the senators and legal counsel, I withdraw my amendment to the amendment.
Thank you. So we still have on the floor the St. Nicholas amendment that's been objected to by the sponsor. Is that still on the floor, or is that? All right. So on the St. Nicholas amendment, all those in favor of the St. Nicholas amendment, please indicate by raising your hand. Motion fails.
I still have the floor, Mr. Speaker.
Yes.
Well, just out of curiosity and a question to the author. Now then, without the amendment, the language reads, the effective date of executive orders shall be at midnight of the day such executive orders are issued by the governor and transmitted by him, the Speaker of the Legislature, under comparative laws. The way that reads, Mr. Speaker, is it will be effective at midnight and it must be transmitted at midnight. So unless I'm misreading something here, I guess we're going to be running a midnight night rider operation to get executive orders through at exactly 12 o'clock on the dot to the Speaker's office and the comparative laws, who probably now needs to run a 24-hour operation. Question posed to legal counsel and the author, Mr. Speaker.
Do you wish to yield to that?
I don't know about that, Mr. Speaker. All I can think of is if he issues an executive order at 4:58, he can transmit it at 4:59, and it's really just up to him to transmit it. And we didn't even dictate the form that he can transmit it in. And as we said earlier, it doesn't depend on the receipt by our body. It depends on the transmittal. I remember the legislature had to pass a law dictating how bills would be transmitted to the governor because we had that same issue, and we couldn't be restricted from transmitting things to him even at midnight or whatever time. And I remember, all the funny ways we tried to get it there with the staff. But anyways, I don't necessarily see that to be an issue. If he works after 5 and issues an executive order and transmits it to the compiler and to the legislature, and it would be effective at midnight of that date. I don't see that to be an issue, Mr. Speaker.
Thank you. Anyone else wish to speak on the motion? If not,
Mr. Speaker, I would like clarification from legal counsel then. Because the way the language is written is it says the effective date of executive orders shall be at midnight on the day the executive orders are signed and transmitted to him by the Speaker of the Legislature. So I understand the intent of the language is for it to be effective at midnight. But we had an earlier discussion about transmittals wanting to have them take place within a certain period of time. The only time that we have here in this section is the midnight timeline. And so when it says midnight and transmitted, I'm concerned that we're saying that it needs to be transmitted at midnight. So unless legal counsel is indicating that that's not the case. So it's effective at midnight, but they can, so long as they transmit it before then. Perhaps we need to include that language then. Brief recess, Mr. Speaker.
Reese. Senator Nicholas, you're recognized.
Thank you, Mr. Speaker. In consultation with legal counsel, it's been clarified that because transmittal is not a specified action, there isn't any necessary concern as to whether or not there's going to be any kind of conflicts with when the executive order is signed and when it is technically transmitted per this act, because transmittal, as not defined in this act, doesn't necessarily create any kind of restrictive process. So it doesn't necessarily need to be sent to your office physically or electronically. It just needs to be as based on the governor's own perspective, transmitted, air quotes. So that being said, there is no concern with the midnight provision, and I guess we can be satisfied with the language, being fully aware of what that of how broad that language is. Thank you, Mr. Speaker.
Thank you very much. Anybody else wish to be heard on the main motion? If not, Madam Vice Speaker, you're invited to close. Oh, wait. Senator Esteves?
Thank you, Mr. Speaker. While I do appreciate the intent of the bill, I do have to rise in objection, non-support of this bill. I think it is my belief that this is a gross infringement on the separation of powers. It's the prerogative of the governor, whoever the governor is, and the chief executive, for their orders to take effect when they believe it to take effect and when they deem that it's necessary to take effect. And putting any stipulation in statute, I think, would infringe on their ability to conduct government business. And again, while I do appreciate the intent and what it highlights to do, I do think it's infringement on the separation of powers, and I object. Thank you.
Thank you very much, Senator Esteves. Senator Lee?
Thank you, Mr. Speaker. I rise in support of this measure and would also like to point to a letter from the governor's chief legal counsel that is submitted along with the committee report attached with this bill, thanking you, the Speaker, for the opportunity to review Bill 71-34 and expresses their support for Bill 71-34. So we have the support of the Governor of Guam, we have the support of the compiler of laws, and I think that this measure will help to increase transparency and just give the public an opportunity to be aware of what we're doing in this government. So I commend the author and I rise in support again. Thank you.
Thank you very much. Any other senator wish to be heard? Any other senator wish to be heard? If not, Madam Vice Speaker, you're invited to close.
Thank you, Mr. Speaker, and I thank all my colleagues for their words and their questions, because I think that always helps to us here on the floor make our bills better. And I thank them for their support in advance. I'm hoping that they will support this, and it is something that I actually want to commend the governor's office for supporting, because maybe they didn't have to, but they did, and I give them a lot of credit. And I think it's very consistent with all the hoops that we have put the government of Guam, put up for the government of Guam to jump through, and really those are all geared towards transparency for the public. We are all serving the public. So if there's an emergency, there's no problem. But when he wants to change policy, when he wants to change the way the government operates, he can still do that. He just does it. It's effective, midnight. That's really all this does. And so I don't believe that it ties his arms at all. It's either an emergency or it gets effective at midnight. And the other side of this is, what does it do for the public? So even if we ended up in an argument over constitutionality 10 years from now when we have a different governor, I think so be it, because this is worth it. It's worth it to give the people of Guam the opportunity to be informed immediately of what is going on in our government. We as senators, we need to know what is going on with the government. We have oversight of agencies that sometimes maybe we don't know what's going on in the agency, and we can't keep track, no matter how diligent we are, if we can't know what the executive orders are. We've already passed laws requiring executive orders to be put on the books, to be put when we go to court, you're assumed to know the law if it's published, right? And you're held accountable to it. And we want our compiler to be able to publish these things. I mean, that's just how we want our government to run. We've already said that. That's the policy of this government. And so I really thank you and ask you to support this bill, and I humbly thank you. Thank you.
On the motion to send the bill to the third reading file for voting, any objection? Thank you. Bill 82-34, Senator Mary Camacho Torres, you're recognized.
Seduce Mossy, Mr. Speaker. Mr. Speaker, I move to place Bill number 82-34 in the third reading file and request permission to discuss the bill briefly.
Any objection? There being no objection, so ordered. You're recognized, Senator Torres.
Thank you. Bill number 82-34 is an act to add Chapter 50 to Title 15 of Guam Code Annotated relative to fiduciary access to digital assets. This revised Uniform Fiduciary Access to Digital Assets is a necessary act to modernize Guam fiduciary law for the Internet age. What this bill does, or UFADA, is it establishes standards for the handling of an individual's digital media accounts upon their death or incapacity. We all know that as technology continues to advance and become a larger part of our personal day-to-day lives, many of us find that we have an increasing number of digital assets. These assets include any electronic record in which an individual has a right or interest, which includes but is not limited to social media accounts, emails, photographs, our books, our music. But more importantly for many of us, our tax returns, our bank statements, our correspondence exist only in electronic record form. And when an individual passes away, oftentimes their fiduciaries are prevented from accessing their digital accounts by password protection or restrictive terms of service. So this bill addresses 4 common types of fiduciaries. It provides rules for executors of a decedent's estate, for agents under power of attorney, for our guardians, and for our trustees. The revised Uniform Fiduciary Access to Digital Assets Act provides legal authority for fiduciaries to manage our digital assets in accordance with the user's estate plan, while protecting a user's private communications from unwarranted disclosure. So this bill empowers individuals by allowing them to specify whether their digital assets should be preserved or distributed to heirs or destroyed. And the uniform law ensures that fiduciaries in every state will have equal access to digital assets, and custodians will have a single legal authority with which to comply. This bill also seeks to respect privacy interests by preventing companies that store communications from releasing them to fiduciaries unless the user consented to disclosure. This is a revised Uniform Fiduciary Act. It was revised from its original submission by the Uniform Law Commission. And I just want to, for clarity of those that might be wondering what the nature of a uniform law entails, this specific act was developed by the Uniform Law Commission, which is a nonprofit that provides state lawmakers with model bills to bring clarity and stability to critical areas of state statutory law. So this Uniform Law Commission, in developing this act, worked with technology companies, trust and estate lawyers, and privacy advocates to update the model legislation that they released last year. And so I urge my, my colleagues to favorably consider the passage of this law, because I think that in looking at the very practical burdens and obstacles that can face our custodians and fiduciaries, there is a need to update this particular part of our Title 15, our trust and probate statutes. And we know, in addressing some of the very practical things, we know how detrimental it can be for families where a person becomes incapacitated for some reason and can no longer access their bank accounts or pertinent information, and their custodians have no access because of restrictions and terms of service agreements and password protection. So it is not only important for what occurs when our estates have to be handled, but it has very practical relevance to what happens to us on a day-to-day basis when we are not able to manage our own affairs with regard to digital assets. Ms. Maasi.
Thank you very much, Senator Torres. Senator Lee, you're recognized.
Thank you, Mr. Speaker. I rise in support of this measure. Much of our life is preserved digitally these days. Our relationships with our loved ones are chronicled through pictures and messages, emails, and posts on social media. And as the author mentioned, we store private documents, we store financial records, and other very valuable material on hard drives, servers, and websites. For those mourning loved ones, accessing this data, whether it's a financial record or photos, can sometimes prove to be a challenge. Many websites do not have policies that allow family members to access accounts, so meaning profiles are left online indefinitely or deleted by companies. Financial data may be similarly inaccessible, stymieing the resolution of legal cases. Bill 82 is an attempt to address some of these issues and bring Guam's laws into the digital age. The bill standardizes fiduciary access across state lines and brings us into compliance with federal laws regarding digital assets. It also allows a person to legally give access to a fiduciary or personal representative, a guardianship or trustee, to manage their digital asset, record, or information, such as photos and emails that are stored online. This protects both the privacy of the deceased and can allow loved ones access to crucial records and personal documents and photos. I know how much of my life is stored online and how important it would be for me to have my family able to access it when I pass away. This law offers a pathway for individuals to protect their privacy while giving their family the tools they need to resolve any personal and financial issues they leave behind. I'd like to thank my colleague for introducing this law, and after attending the public hearing and having questions answered, I was able to gain a better understanding of this important issue. I stand in support of these efforts to update Guam's laws for the digital age. This is an important step for Guam in modernizing our legal system to reflect the needs of the 21st century. Sujus Masi.
Thank you very much. On the main motion, Senator Uggan and then Senator Nicholas.
Thank you very much, Mr. Speaker. Mr. Speaker, there's just one particular question I would like to inquire with the sponsor of the legislation, and that is whether, in fact, Bill number 82-34 would allow for the transfer of bitcoins to the heirs, or would that be classified in a different category?
Are
Please,
you
Mr.
able
Speaker.
to answer that? Do you yield? Can you?
1 minute recess, Mr. Speaker, please. Thank you, Mr. Speaker. Thank you, Mr. Speaker. And to the sponsor of the legislation, I believe she does have a response to the question, which is whether this particular proposal would be inclusive of the transfer of bitcoins, which are considered digital assets.
Yes, Mr.
Senator
Speaker,
Torres.
I'll yield to the question. Although I'm not familiar with what a Bitcoin is, I do believe that if it falls under the definition of a digital asset, under Section 5002 definitions, in this act, an account means an arrangement under a terms of service agreement in which a custodian carries, maintains, processes, receives, or stores a digital asset of the user or provides goods or services to the user. So I believe that in that instance, that would constitute an account under definitions of this act.
Okay. Thank you very much, Mr. Speaker, and thank you to the sponsor for the response.
Would both of you look at subsection 9? Page 4, under definitions.
Yes, that is correct, Mr. Speaker. Digital asset is also further defined on page 4, line 20, under section 5002. Digital asset means an electronic record in which an individual has a right or interest. The term does not include an underlying asset or liability unless the asset or liability is itself an electronic record.
I know. And so I'm just, well, both of them have been now read into the record. All right. Thank you. And Senator Nicholas and then Senator Castro. Senator Nicholas, you're recognized.
Thank you, Mr. Speaker. Mr. Speaker, I generally rise in support of the measure. I do have some concerns. My primary concern has to do with page 6, line 19, under applicability. This act applies to, on line 19, a personal representative acting for a decedent who died before, on, or after the effective date of this act. Personal representative is defined on page 5, line 16, means an executor, administrator, special administrator, or person that performs substantially the same function under law of the state other than this act. Now, my concern, Mr. Speaker, is when someone passes away, the court would typically appoint, if there isn't already a trustee, the court will appoint an administrator of an estate. But the definition of personal representative here is not necessarily limited to court appointed. And I'm just concerned that because it's a little loose, this individual can go and act through this law for a decedent and then begin using that function to start accessing certain things that perhaps the decedent wouldn't have wanted them to. For example, let's say when, prior to you passing, you sent some emails about some of your survivors, and you were discussing how you're going to treat various survivors, or some of your perspectives about various survivors. And after you pass, those digital opinions of yours could be accessed by this personal representative. And because it's not as narrowly defined, could anybody basically just call themselves or hold themselves out to be an executor, administrator, or special administrator for the purposes of fulfilling the definition of personal representative, and then use that to carry forward the applicabilities that are granted unto that person under this act and begin accessing all of these electronic records. I would prefer that we narrowly limit it to the specific person that is appointed by the court or that is named as a trustee. And I'm not sure if the definition of personal representative is tight enough to limit it to that. So I guess I would pose the question to the author and perhaps ask legal counsel if they can help further clarify.
Senator Camacho Torres, you wish to yield.
Yes, I think what I'd like to point out is this provides legal authority for fiduciaries to manage digital assets in accordance with the user's estate plans, while protecting a user's private communications from unwarranted disclosure. So this act, in fact, complies with federal laws. And under this bill, fiduciaries must provide proof of their authority in the form of a certified document. So the custodians of digital assets that comply with a fiduciary's apparently authorized request for access are immune from any liability that prohibit unauthorized access. But a fiduciary's authority over the digital assets is limited by federal law, including Copyright Act and the Electronic Communications Privacy Act. What I want to be clear is that with this law, there has to be an expressed desire and consent by the owner of the assets. Without an expressed desire of their wishes, including, as I mentioned earlier, what should be transferred, what should be destroyed, what should be disclosed, what should not. It's very specific to the desires of the owner of the assets, digital assets. So I believe that that concern about somebody inappropriately representing that they have some certain rights over accounts is very limited to what the courts will recognize as the authorized and legitimate fiduciaries, whether they are the executors of the estate or the agents under power of attorney or a trustee or a guardian. Those are very specific and legally recognized authorities over somebody else's assets. So I also want to caution that in looking at amending uniform law, this revised Uniform Fiduciary Access to Digital Assets Act was done in a comprehensive manner by the Uniform Law Commission. And one of the concerns that we want to always bear in mind is that uniformity is exactly that, changing it in some way to where it doesn't comply with a standard that's used across the nation and through the territories will not work to the ultimate benefit of or the utmost benefit of the asset owner. And we do know that this language contained in this act has been approved by Facebook, for example, and Google, and has also been endorsed by the Center for Democracy and Technology. So I would caution us, against altering anything here that might compromise the effectiveness of this uniform law across state lines. And as such, we've got, presently 30 states have enacted this legislation, another 14 have introduced it, and Guam stands to be the first territory to pass such a measure. The Commission recognizes that it's important that the one standard be applied across all jurisdictions that adopt this, and not, and that we shouldn't we shouldn't mess around or change something that may not be applicable or may not be recognized by some of the custodians of these records.
Thank you.
Thank you, Mr. Speaker. I fully respect the concept behind having a uniform standard. My concern is that when members of our community appoint administrators of their estate, they're not doing so with an awareness of what that is going to be empowering those individuals with. I'm concerned that perhaps we need to include some kind of language in here that requires a disclosure of some type to be given to an individual when they're going to be appointing and having those types of individuals formally recognized. If we pass this, every single person who's been appointed a trustee will now be able to, in that capacity, access the decedent's emails or what have you. If there's a court order. So for example, on page 9, starting on line 3, disclosure of content of electronic communications of a deceased user. If a deceased user consented or a court directs disclosure, the contents of all the electronic communications of the user shall disclose to the personal representative of the estate of the user. So I just want our people to be aware, maybe stating it for the record is sufficient, that the person that you're appointing in this capacity is going to be able to read everything. And including all of your electronic communications at this point. Because prior to this, unless I'm mistaken, because there's no uniform law, unless it's existing in code that those certain documents can be released, or unless the court finds a compelling reason to release them, it dies of the decedent.
Or it could be the other way. We leave this intact and amend something in Title 15. Under the probate code to expand what an administrator must be aware of. There probably is a provision there that could address this by doing that instead of amending the uniform code.
Sure. What I'm trying to just make sure we are fully aware of as we do this is that, that I'm sure that there are individuals out there who have a lot of electronic correspondence that they would want to have die with them. Text messages, WhatsApps, emails. Those will all technically be accessible by whoever the administrator is of your estate if the court orders that electronic communications be so accessed. Right now, at least, and I'm speaking strictly from a layperson, a lot of our perspective in our community is that if there's stuff that we want to be administered, we keep a file of it, we keep a record of it, we let people know about it. My other half has has all the passwords to everything that I need her to get to, and I think that that's a pretty common thing. But what we're doing with this act now is we're creating a means for all these other information that's out there electronically to eventually somehow be accessed. Another concern that needs to be raised, and I'm not sure if it's included in this act, and perhaps I can pose that question to the author, is there a mandate for confidentiality? So let's say the court allows for the administrator to access the records, and the administrator finds certain things in there. Can that administrator share that information? Would the decedent have wanted that information to have been shared? There's a lot of other implications here that I think we're touching into, because this is just basically opening up a whole new area. So I wanted to raise them for the record.
I don't think it's this that's opening a whole new can of worms. I think it is the digital age that's opening a whole new can of worms, in that many of us do not understand or fully comprehend the asset that we have in that. and probably should include in our will or whatever, documenting how we want our assets distributed and addressed, what can be addressed, what can be should remain confidential, and what should be burned before anybody has a chance to see it.
Mr. Speaker, if I might also add to that concern, within the Facebook and the Google terms, a user can opt to designate another person to have access to their thing or to be given the rights over their accounts other than someone who's named as an executor or a trustee or a guardian or an agent. And Facebook and Google recognize and will defer to based on this act, or in concert with this act, they will defer to the expressed desires and opt of the account holder. So, for example, if I do not want the named executor of my estate to have access to my Facebook account or my email accounts, I can designate, for example, my daughter to be the person who I entrust with this account. So upon my death, Facebook and Google will allow for only my daughter per my expressed wishes as I opt in my agreement with Facebook and Google. And that person will be the person that they will allow access to. Now, that's where this law is so thorough in that it protects and it contemplates all those privacy considerations. Exactly what you want to be divulged, what you want destroyed, how much. It's very clear, and it gives control to the owner of those assets. And it actually addresses some of the prior default provisions in the earlier version of this act that they felt was too broad. So it actually narrowed down and satisfied those very concerns by Facebook and Google that had to do with those very personal types of assets that you really want to die with you, or you would rather have someone you trust to continue to manage it or to preserve it for posterity purposes. They had all those considered. So I believe that, the whole realm of federal law that deals with cybersecurity and anti-hacking laws are very, very complex. But what this bill does is it allows us to have those assets managed and accessed where under current law, under current federal law, our executors or fiduciaries would not be able to.
Thank you. Anything further, Senator Nichols?
I appreciate the statements from the author, and I think what she said in the end is key. What this law would allow is access, whereas otherwise that access would not be allowed. And if everybody's operating under the assumption that that access is not allowed currently, and we thereafter allow that access, even within a very narrow framework, it does very much change the reality for everybody. What you think is private or that you think is password protected at a certain point will not be. And those are some serious things to consider. Something you also said, Mr. Speaker, is important to consider about the digital age, and that is that it's constantly changing. We're talking about Facebook today. 10 years from now, we're going to be talking about something else entirely. But when you pass uniform code that applies to all digital assets, everything that happens in the future is going to be inclusive under this act. So these are all things that are, I think, important for us to take into consideration as we weigh what this bill is seeking to do. I understand that the intent of it, and this is my interpretation of the intent is...
And this is the second iteration, as was mentioned by the sponsor. There was an earlier version of this that they're now tightening. And the agreements that you have with Facebook and Google and all those, which I don't know who reads them before hitting accept, but you do, is fairly expansive. So we're trying to address it in a uniform way as opposed to an OOG.
No, I understand. The reality that we have 30 states that have adopted this and 14 others considering it does put it into perspective for us that maybe this is something that we need to have. But at the same time, too, Mr. Speaker, there are some communities in this world that are actually treasured for their privacy rights, as opposed to uniformly creating the mechanism by which they can be accessed. And I wanted to have the conversation. I think it's important for our community to know. If you're going to be appointing someone as an administrator, this uniform law, uniform as it may be throughout this country, is also going to create a uniform way for your digital information to be accessed. Digital assets, certain things of value, I can totally understand the need for us to be able to fully vet them, but I think privacy is another thing entirely, even after you're dead. And sometimes less access is what people want. Thank you, Mr. Speaker.
Thank you. Senator Castro, was it all addressed during the discussion? Senator Morrison?
Thank you, Speaker. Mr. Speaker, I just want to ask the authors if you could yield to some questions. On the question, it states here the Digital Assets Act revised in the UFADAA. How recent was this revised, and through what process was this vetted? I mean, the previous speaker mentioned we are in the digital age and everything is changing rapidly, but as of when was this revised and how current it is? I bring this up, Mr. Speaker, because there's talk about what's happening in this world and where we're at today and where we're going, and there are softwares out there that are making it very clear on how we're completely decentralizing this world through digital assets and using certain protocols that are on the cloud that everybody can have access to, and ensure that not only that, but protect the privacies of those who have information in the cloud. I just want to know how recent was this revised? It's and through what process was it vetted through? I mean, I know with the federal government, there's caucuses formulated within Congress to address the types of movements with digital assets, those that have monetary value, those that deal with digital smart contracts, how we analyze information. These are all things being put up on the cloud, and they could be accessed digitally. So I'm new to learning of this Uniform Fiduciary Access team, or I'm not sure if it's a team, but of probably experts that handle these stuff. If she could yield.
I'm not that itchy, Mr. Speaker, but I do want to rise in support of the bill. And as I understand it, unless I hear otherwise, this is primarily about disclosure and access and the disposition going back.
Point of order, Mr. Speaker. I'm just wondering if the prior speaker had asked a question for the author of the amendment to yield to. And I thought maybe the good senator speaking now was going to rise supportive information, perhaps to add more light on the issue. So.
I'm not sure which cloud we're on right now.
It's nice to follow rules, isn't it? I'm very inspired by the questions because it highlights the complexity of this and how we really have to not only consider what the practical applications and challenges are, but why this piece of legislation is necessary to address those concerns. I'm going to read, paraphrase from a document that was written by the Center for Democracy and Technology. And this document was prepared in 2015, but it discusses a little bit about the process that the retiring speaker had asked about. As I mentioned earlier, the Uniform Law Commission provides state lawmakers with model bills that would help clarify. So in this instance, they worked with all the known stakeholders that would have an interest in digital assets. And that would be technology companies, trust and estate lawyers, privacy advocates. And what they did was they introduced a year prior, in 2014, they introduced the first Model Act. And then they came back with a revised model to address several of the objections that were raised in the prior model, which substantially shifted its default treatment of digital assets. So what was changed in this new act is it protected communications by default. This bill requires the consent of the user before granting access to contents of the digital communication. So there's not an automatic default to where when you die, your executor therefore has complete access. Users can expect that their communication will be private, and they can take steps to ensure that. So the treatment of the assets under this revised thing is more accurate reflection of the technology and is more respectful of the user's control. Also, it prioritized the selection made through online tools. So this act gives priority to the wishes expressed through tools like Google's Innovative Account Manager or Facebook's Digital Legacy Content, even over the wills and other testamentary documents. So going back to, can I control if someone has access automatically? You absolutely can, and that's what this act provides for. So going back to my example, if I desire that my daughter, over a named executor of my estate, should have access to my emails, and only my daughter, then that's what this act will default to. Also, the terms of service are given the lowest priority. The original model that came out completely negated any provision in the terms of service agreement that prohibited access. However, this updated bill appropriately recognizes the role of terms of service agreements. So it incentivizes the user to express their desires directly through provider tools or testamentary instruments. This Act's recognition of the terms of service acknowledges that the users may have chosen a particular provider or service based on the expectations that are rooted in the terms of service agreements. The Uniform Law Commission promotes its model across the country and has prepared helpful charts to help lawmakers go through it. But what we want to do is we also need to encourage the state lawmakers to keep the privacy and digital dignity in mind as they decide what legislation to introduce this year. There are several models out there, but a lot of them are not as specific and comprehensive as this RUFADA is. So I hope that answers the question in terms of the timing. We do know that this measure was initiated around 2014. In 2015, over the course of the year, they worked with all the stakeholders. who felt that the default provisions were a little too broad, so it narrowed it. And this is the product that many of the major stakeholders have identified as being usable and allowing access while protecting the privacy of the individual. But again, it all boils down to your expressed desire as the owner of an asset. So there is not an automatic default that we would worry about. And of course, in the nature of the Uniform Law Commission, they're always looking at ways to improve upon things and looking at statutes that have application across the states. And as I mentioned before, this product is a collaboration of many to address the concerns of everyone, but most specifically, considering what is most practical and useful and beneficial to holders of digital assets and their fiduciaries, and how to make that work in their best interest so that existing federal law doesn't compete or conflict with them being able to just discharge their duties as fiduciaries. Thank you.
Senator Morrison, is that sufficient?
I think so. I'm getting there. I appreciate the author addressing this matter. I'm just reading through this, and my simple thinking, when I read that provide proof of their authority in the form of a certified document, I'm thinking, today we have extra security beyond the, passwords. They're called two-way authenticators, where you hit a prompt with a code so you get extra access, or you have Google authenticators to authenticate to an extra layer to your phone, your smartphone. And now I'm thinking, with my heirs or my wife, if she had access or had at least that information provided in a document that I gave her access to, and she had those keys to enter into accessing my digital assets, does that satisfy my consent? But this says certified document. What type of certified document are we referring to? Is this has to go through a process of a will, or I'm just trying to think simply, hey, here's a document. This is access to all my information. Does that already consent? And what other process do I have to go through to certify that? But if it has my signature on it on a blank piece of paper, I'm just wondering, does it need to go through this whole layer to provide my consent? Or does that certify?
That was the same problem my great-grandparents had when they thought that they gave the land to everybody, when they said everything past the coconut tree is yours, on the other side of the river is yours. But now the courts are saying, unless it's written and it's witnessed by two people, it's not acceptable. So now we're in this digital age, and everybody's worried about their digital assets. Before you press send or join to anything, you should have thought about it, because it's out there.
Right. No, I'm just trying to point this out because I understand we're trying to protect people here, but at the same time, I just feel it's kind of going a little too far when, in a sense, if a person has not access to your passport, but to your specialized keys, and through what we call it now, if anyone knows, a two-way authenticator, then that validates the person has either the ability to have some specialized skills in hacking someone's information, or it was clearly a consent by that individual. But anyways, I'm just putting out what I've done, and I'm reading something here that may cause for me to go through a certifying process to ensure that whatever I leave with with my heirs or my family may not be valid enough for them to hold in court. But so you're saying that would not count as anything to certify, that if I was to give these specialized keys and access, it will not state that I've certified that this is access to my family, for my family to get into. No?
I don't know, and I'm not embarrassed to admit I've not read one of the agreements that I've signed on to. But those of you that have read it, tell me, because it's really long. Senator Torres, do you wish to respond?
I just want to point out, Speaker, these things today, do you understand we are in a digital age, and that's why there is software available or applications that are being put out there to protect the individual's privacy, or not mainly from hackers, but just personally for their own family's access. And I want to ensure that if we're putting something in place, that we're not creating an extra layer that's already been put in place to validate people's access within their own homes or their own households, and ensure that they have their own protections. Now, I think the previous speakers also pointed out that, heck, if the NSA can get hacked, anybody could get hacked, right? And I'm just wondering if more information that we're putting out to certify through some process, that we're giving those with specialized skills a pawn to go to and search information. Because I know it'd be certified and put somewhere on some public ledger or some ledger for someone to have access to. So I'm just pointing it out. That's how I operate, at least with these accounts, even with my bank account or stuff like that. There is extra layers to protect your account. And fine, you know my passport, but I don't think you know my other authentication to get in. If you do, then, But anyways, I point that out because it does point out that it has to be certified. I'm not sure what that process would be.
Senator Torres, do you wish to yield?
I just want to point out, as we have these discussions about the practical application of what we do now, and we're dealing with Title 15, which is estates and probates. This act is intended to address how to handle digital assets upon our death, but it also provides for how to handle our digital access if we are incapacitated as well. And the whole handling of estates and probate is a matter for when we are not in a position to dispose of our accounts or our assets, or to close out our existence. That's what our estates do, right? We probate it and we finish the business of the person who has died. We dispense of their assets. We carry on if there are any transfers that need to be made, or those things are accounted for. So what we do in our active life and stuff, this bill will then address what happens when we are A, no longer here, or B, people can't live indefinitely through other people acting on their behalf when they're deceased. So we just have to, let's not get ahead of ourselves, and let's just think about it for what it is. This is an amendment to Estates and Probates, Title 15, and it is specifically with how to handle those things. Well, right now we're not able to. There are impediments to accessing it. So what this does is it just gives us a mechanism that has been thoroughly contemplated to deal with those assets, because right now, with all the federal protections in place, from anti-hacking to privacy issues, our hands are tied. So this gives us a very clear mechanism for how we can proceed to either close out a person's estate or to deal with a person who's not able to care for themselves. And it's all within the confines of the law and all within the recognized and lawfully proper fiduciary. So, it's very good thought processes, because it just draws the importance of how we have to deal with this, and it's very real, and it's not contemplated now in our statutes, so we have to provide for it. It's something that's not provided for now, so we have to provide for it. But in terms of how much we want to do and how much we want to divulge, that is very specific to consent. And that's where I want to draw the line. That automatic default that in our earlier version seemed to be problematic and overly broad has been addressed. But I certainly appreciate all the comments and the thoughts that have gone into this proposed piece of legislation.
On the main motion, Senator Castro, do you wish to get please, at this point, now you can state your support, not when you're trying to answer a question and the point of ordered out. Okay. Madam Vice Speaker.
Thank you, Mr. Speaker. I rise in support of this bill, although I think that the concerns that have been raised are very valid. It's a challenge. It is going to be a challenge for the people of Guam and everywhere. That what this bill does is it brings digital assets to be treated the same way as our other assets, whether we like it or not sometimes. And it's really been, for me as a lawyer, one of those challenges is that we feel like the public doesn't know enough, that they need to dictate what they want to happen before they pass away. Otherwise, the law kicks in and these things will be done automatically. They be treated pursuant to the law, whatever the law dictates. And so we've done this before. We've passed policy that says what the law will dictate when you die, who gets your assets, whether you like it or not. And so this type of thing, I think, really does put a burden on the community to be informed and to plan. And it's tricky. I'm not really digitally savvy, so it's a challenge for me, I think, personally. But it's one of those things. I've seen some investment online tools recognize when you become an administrator, they will recognize that and they'll take care of it. They allow administrators to act or do what they need to do with online investment tools. But this takes care of all those other things. Or when you don't dictate what's going to happen, and it's an asset of the estate that's involved, then it allows an administrator to do what he needs to do to get access to that asset. And so I think it's imperative that we help our community to plan for these things, just like we try to do with land, and that we always remind them, take care of it before you die. Otherwise, the law is going to dictate what happens in these things. And some of these things, as a concern has been brought up, are very, very private. I was not even aware that I could dictate on Facebook what happens to my Facebook account, so I'm going to check into that. But that type of thing, it's a matter of, with everything that changes, we have to just continue to educate. And I remember when I was contracted with Public Health years ago. They have a legal services for senior citizens. And that was, of course, for senior citizens, the biggest thing is planning what happens after they die. And so I just think we have to always ensure that those kind of services are provided, that attorneys become informed of this new law so that they can advise those who come in. But I think the bigger issue is those that do not come in. We need to somehow let everybody know that this is the new law, this is the new way things are going to be handled after you pass, or when you become incompetent, and it's significant. And that you can dictate otherwise. So that is their option, and that's the power that they have if they're aware of it. So I thank the sponsor for this law. I think it's important that we deal with these things. I've also seen cases where they're almost it's a nightmare to deal with. So this will assist, and I think the fact that this is still consistent with the uniform law, and so it will be consistent with what is used across the states or those that have adopted it is also very good. I think the bill has protections. It's just that we have to know how to utilize those protections. And of course, it also says that federal law can also, it trumps this bill. If they pass another law that says this is not possible or something like that, that will always prevail. So I think that there are protections enough. It's just that scary thought of if you don't know or you didn't do it, and you know, it's the same thing with your other assets, then they will be treated maybe sometimes contrary to what you had hoped for. So it's kind of a somber reminder to all of us of why we're doing this bill. It's because of what happens when we die, and we need to take care of those things. So I thank the sponsor, and I support the bill.
Thank you very much, Madam Speaker. On the main motion? On the main motion? Anybody else wish to speak? Otherwise, Senator Torres, you're recognized to close.
Mr. Speaker, I just want to extend my gratitude for the body for their active participation in debate and discussion. I think that it is so important that we understand what we need to do, not only to protect ourselves, but how we need to reach out to others so that they don't fall into situations that burden their families when they are in a position of incapacity or when they expire. So I thank everybody for their active discussion, and I hope that if you are still a little fuzzy about some of the details, there's some material that's contained in the committee report that can give you a little bit of a summary of what exactly we're looking at and how this piece of legislation came about. And I respectfully request the support of the body in passage of this measure. Thank you.
On the motion to send Bill 84 to the voting file, 82, I'm sorry. Bill 82 to the voting file. Any objection? There being none, so ordered. Senator Adda, you had two bills set aside.
Yes, Mr. Speaker. First of all, I would move that Bill 18-34 be sent back to committee.
On the motion to send Bill 18 back to committee, any objection? I believe
And
34?
Bill 13-34?
No, 34-34.
34?
That also was set aside.
If I could, I would like to go ahead and pass that on file, and so that we can get down to Bill 13. That's the last bill that I have.
Okay. Is this one going to go for hours?
Oh, no, this one, 10 minutes. Bill 13, 34? I just, because of our time constraint, I would like to pass on that and really get to Bill 13. So can we proceed with,
Okay. You're going to pass on file?
pass on file on Bill 34,
Yeah, okay.
which then brings us to Bill 13.
Go ahead.
Yeah, so Mr. Speaker, I move to,
Sorry, Mr. Speaker. Is this the one that was added to the agenda? Yeah.
Yes.
Do we have copies? I don't see them.
Yes.
I'm sorry, I'm going to keep checking, but could we get a 3-minute recess or 1-minute recess? Just,
so for
Let's-
logistics purposes, first of all,
Let's-
Bill,
Let's take a short recess.
everybody should have a copy of this map.
Test 1, 2.
light of the hour, let's take an early lunch. I understand there's a presentation being made in the public hearing room. And for those of you that need to discuss 13, please remain in this room and discuss 13. And those who want to attend the presentation can attend the presentation. We'll do 79 and then 50 after lunch. We're in recess until 2 o'clock.